হিয়ারিং এ এতগুলো মামলা দেখা হ্যাঁ না না
This matter needs to be pushed to next cycle because I have been granted leave to add a party within the array of respondents. The necessary correction has been done just few seconds ago. So let me solve that gentleman and come back to you.
হুম হুম added respondent is yet to be served. Yes, and then by Copeland and advocate for the petitioner. Please the matter for the next available circuit bench to enable the petitioner to serve the added respondent.
Completely.
My lord, I appear for the petition in this matter.
And for the respondents. This is that matter, my lord, he has filed an
My lord,
application.
I applied for a economically weaker section certificate. Now that has been rejected by the authority concerned with the remarks as insufficient document. Though it was not clear as to which documents were insufficient, only after reaching this honorable court, they gave a list raising certain concerns about my application, which were placed before this honorable court on the earlier occasion by my learned system.
My lord has also directed him to submit all those documents before this honorable, because it is not annexed with the writ application. What are all documents he has submitted before the concerned authority for issuance of EWS?
My
So
lord,
that what documents he has submitted, that has to be placed before this honorable court to see what are the discrepancies, my
What
lord.
were
Because the name of the father is incorrect, my lord, and the residence, it is of different. So there is a mismatch of documents, my lord. So until and unless, because on the last order, my lord, your lordship has directed him to submit all those documents before this honorable court. What are all documents that he has submitted before the authority?
my lord, I'm praying for 5 minutes of time for myself so that I can demonstrate everything without any distraction between by my learned sister. Whenever I try to say something, she jumps in between. So if I'm allowed, then I can clarify everything.
Fine.
Now they have done their part by submitting this particular report, which is perhaps there in the record, which was submitted by my learned sister on the earlier occasion. So before I get into that particular list of concerns which was raised by the authority concerned, I would like to demonstrate my situation as to how I am in these islands and how I have been raised and everything. My lord, first of all, my lord may come to page number 18 of my writ application, annexure P3. My lord, admittedly, I was abandoned by my parents who were laborers in these islands. They were working at Little Andaman, Hut Bay. When I was in 10th standard, I was abandoned by my parents and they left for mainland forever and they never turned back here. And here in this newspaper cutting, they have clearly reported all these things and I was rescued by one of my teacher at that point of time. His name is Shubinay Dey. This is clearly mentioned in this newspaper cutting, which is a local newspaper here in these islands. If required, it may be read, it's a little unclear. It says it was reported on 12th June 13th June 13th June 2017. It says a child of Little Andaman who was under very difficult circumstances some months ago and was later rescued by a kind-hearted teacher has performed extremely well in class 10th. As per details, the child was made to work as an unpaid child labor by a landlord of Little Andaman, namely Mukul Aulia. The child was left behind by poor parents at Little Andaman a few years back. Mukul Aulia, the class 10 student of GSSS, that is Government Senior Secondary School, VKpur, scored 9.8 CGPA or cumulative grade points average is also said to be the topper of the Little Andaman class 10, setting an example of courage and determination towards his study. So, after being rescued by my teacher all these years, he took care of my financial needs and all. So later, out of love and affection, I thought of adopting his surname. It was not an adoption as said by the authority.
Can you do that?
Well, I have adopted the surname of my
Can
teacher.
you do that?
Well, there is
You
no
were born to someone.
my lord.
You were born to someone.
My lord.
He left you.
My lord.
That means you will adopt anybody's surname.
No, I don't mean that, my lord. But as an individual, after I attain majority, I have all the right to change my name or surname. There is no bar to that effect. And accordingly, and following the due process of law, I have adopted the surname of my teacher. And that was published in
Because
Act 4 of the India Gazette, which is annexed as P2 collectively, page number 17 of my application. With respect to change of name or surname, this is the ultimate document which is accepted everywhere, my lord. So, the concern raised by the authority concerned regarding my surname, which is differing, this particular document will clarify as to why my surname is appearing as Day at a later point of time, and in all my earlier documents why it is appearing as Aulia. Earlier it was Mukul Aulia, now it is Mukul Dev. And this is completely legal. There shouldn't be, I mean, due to this, it should not be an embargo. Now, my lord, the list which has been handed over by the authority concerned may kindly be seen. The first point, it says that father name is not mentioned in Aadhaar card. My lord, after the change of, after the correction of my surname, when I applied for a fresh Aadhaar card, they gave it without my father's name. It was not me who did something, but my father's name can be clarified from the other documents which I have submitted, the local certificate which was provided by the authority concerned only. When I was studying in Little Andaman, Hadwe, which is also again there in South Andaman only, number one document, the Tahsildar Little Andaman was pleased to issue this particular local certificate to me wherein my father's name is clearly appearing. Even in the Gazette notification, my father's name is there, the same name, Sukumar Aulia. Now, what does this particular document say? This particular local certificate. This is nothing but a domicile certificate. It clearly says that I'm a permanent inhabitant of these islands, South Andaman. Point number 2 in that particular document may kindly be seen, which marks me a person who does not belong to any of the categories above, but who has had minimum 10 years continuous education in the islands leading to acquiring of the minimum educational qualification laid down for the post under the Andaman and Nicobar administration to which appointment is sought. This is basically given to a person who completes 10 years of formal education in these islands. They are considered as local people of these islands. And that is the reason this certificate is called a local certificate. So there is no departure from this fact that I am a permanent inhabitant of these islands. This particular document, which is issued by the Andaman Nicobar administration only. which was given, submitted before the concerned authority in this matter.
What are, madam, what are the other documents you need?
Now, second point.
Let him finish first, John, my lord,
If I
then
may.
I'll start. Let him finish first.
Now, with respect to father's name, that has been clarified by. Now, regarding the second point, which is local certificate, as per certificate, the local certificate, the one I just showed. As per local certificate, the petitioner's residential address is VK Pur, Little Andaman, and name is Mukulalia. That has been already clarified. VK Pur as Little Andaman, as because at that point of time I was studying in Little Andaman. But later I shifted here to Port Blair and thereafter to Kolinpur, which is again in South Andaman. All the places on
You
South
don't
Andaman.
have any document at Port Blair?
Port Blair I have given, ration card I have given.
Your residence?
Yes, second document I have placed, which was placed before the authority also. The ration card clearly shows that I am a resident of Kolinpur village. It was issued in the year 2020, my lord. Kolinpur, Fararganj, the tehsil concerned. So with respect to address also, it has been clarified that I am a resident of that particular village called Kolinpur, which is under Fararganj tehsil. So this particular concern is also resolved. Now, petitioner applied for EWS in the name of Mukul De. That was clarified regarding the name. Income certificate in the name of Mukul De. Yes, because I changed my name, so it was applied in the name of Mukul De, and it was income certificate was given by Andaman Nicobar administration only.
Prior to the affidavit.
Prior to the application, yes, prior to the application
Change of name.
to be made for EWS, I had to apply for income certificate. So even income certificate was issued by the administration.
No, you
Now-
change your name
In the year 2024, my lord.
before applying for the annual income certificate.
Yes. Yes, before applying for annual income certificate. Well, basically, I'm a student. Currently, I'm pursuing my post-graduation in mathematics. Regarding that, also I have NS documents. Now, point number 5 says no any adoption certificate document submitted by the petitioner. Nowhere I have mentioned that I have adopted. I was adopted.
Not required.
Not required, and I was not adopted, admittedly. I don't know where from they gathered this information.
You have just changed your surname.
I just changed my surname, and to that effect, I have sworn an affidavit which was sent to the sent for this one also, the India Gazette notification. In that affidavit, in para number 2, I have mentioned that for the aforementioned reason, I intend to adopt the surname of my guardian, Shri Subinoy De.
Next.
That is the reason they thought that I have been adopted.
Point number 6.
My lord. Point number 6 says that as per the affidavit, petitioner adopted father name. This is a wrong.
There was no adoption.
There was no adoption. So this was wrongly conceived by the authority.
Yes,
And
madam.
I've given all the documents. I'm a permanent inhabitant of these islands, Kolinpur, and later they have said that I don't reside in that area. Well, this report was given in the month of August, 1st of August 2025. All my documents are saying that I am a resident of Kolinpur village. Let them go to the village, to my place, to the house of my teacher's friend where I am residing. Because I personally do not have my own house.
Where
My
is
lord.
your ration card?
Ration card, my lord, I have just given the documents. Document number 2. Page number 2.
Director of Civil Supplies. And it was issued when?
It was issued just beside the address. It is mentioned 13/11/2020. Even my voter ID card, it also has the same address, Kolinpur. Fararganj Tehsil.
Yes, madam.
Lord, at the time of applying for the certificate, my lord, the EWS certificate, one person has to submit certain documents which are mandatory documents. So what are those documents, my lord? Photograph of the applicant, proof of identity of the applicant, family income certificate, local certificate, islander card, ration card, parents' ID proof, one affidavit, and individual income certificate. So, my lord, this particular writ petitioner, he has not submitted his islander card, which is a mandatory document on the basis of which they'll issue the EWS certificate, my lord.
Islander card.
Islander certificate, islander card, my lord. Islander
What is
identity
this
card.
What is this certificate at page 1?
Page 1, my lord.
Have you supplied those documents? Today's documents.
এইটা দেখে নাও।
Today, this is the local certificate which he has submitted, my lord. Page 1 is the local certificate. Second one is the ration card.
Ration card.
Third one is the Aadhaar card. The fourth one is the affidavit. The proof regarding that he is an islander identity card, one card is there, my lord, who resides continuously in these islands. They were
That is
issued
not
with the
within.
islander identity card.
That is
Everybody
not
has.
fitting.
This is
It
not
cannot be
submitted.
because my parents were not islanders.
Because
admittedly.
while
But I stayed here since my first standard.
there is a
and
checklist.
When I was in 10th standard, I was provided with a 10 years
All
certificate,
these-
10 years category.
Island.
Who are also islanders.
10 years means thereafter you were not residing over here. They were just shifting to one or the other place. Somewhere it is written in the Gazette notification, if my lord sees, the residence is written as Shadipur.
Shadipur, yes, that is the address of my
Thereafter
teacher,
he-
correspondence address.
He has filed some affidavits stating that he is a resident of Collingwood. And while applying for this EWS certificate, he has recorded his residence as Collingwood.
Even the,
But he has got no such document to show that he is a resident of Collingwood.
দিলাম তো রেশন কার্ড ভোটার কার্ড সবই দিয়েছি।
ration card.
My lord, VK Pur. This local certificate, if my lord sees, it's VK Pur.
Local certificate says Vikepur.
My lord, I was there in Vikepur at that point of time.
Lordship.
But it does not mean that I cannot change because I do not have my own house. I had to shift.
My lord, may kindly.
And for further studies, I had to come here to Port Blair only
This is
because there is no college.
My lord, he is not entitled for EWS. Why I am saying so? My lord, may kindly come to the page 2 of his document, that is the ration card. My category C may be seen, my lord. Category APL,
APL.
above poverty line. Then how he'll be considered as economically weaker section?
I'll clarify on that.
He is
I'll
above
clarify.
poverty line. He should
I'll
be
clarify on that.
below poverty line. From his own document itself, it shows that he is not entitled for EWS.
My lord.
He comes under the above poverty line, my lord. APL category.
And what other documents required?
Islander identity card he has not submitted. What instruction on submitting, my lord? On last occasion also, I have submitted certain documents, my lord. Why this application was rejected? His application was rejected on the basis of that. What are those documents? There's some mismatched documents. Somewhere it is father's name is some different, and somewhere it is different. But Gazette notification in which he has shown that his name has been changed, but the residence is of Subhash Nagar, Shadipur. Somewhere it is Vikepur. Lastly, it is of Collingwood. So continuous stay in one place, he could not be able to show that document.
But,
That is the islander identity card. He is staying continuously in this island since birth.
My lord, all the
That
addresses
is
are of South
islander
Andaman
identity
only.
card, which is a mandatory document to be submitted at the time of issuance of EWS, at the time of
what is the
making the
problem
application,
with,
online
the
application.
islanders
The
card?
checklist is there, my lord.
My lord,
What is the problem in having an islanders card?
my lord, I cannot be, and islander card It was stopped since
7.
2016. First thing. Since 2016, it is not being given to anybody. There was a cutoff date. It is known to the authority as well. Now, an islander card is given to persons whose parents were islanders earlier or who were given certain settlement. And most of the islanders have OBC here. They have been given OBC. I am not entitled. I did not plead also that way.
I'm not
I am
concerned also
saying
with
that
OBC.
I am a permanent inhabitant of these islands, and till the time I do not have an income of 8 lakh rupees per year, and I do not have uh, 5 acres of agricultural land or above, or a residential flat of 1000 square feet or above, or a residential plot of 100 square yard or and above is in notified municipalities, or a residential plot of 200 square yards and above in area other than the notified municipalities. These are the criteria which has to be seen for issuance of an economically weaker section certificate, which is there in their portal as well and in the office memorandum issued by the government of India. This may kindly see. So. Office memorandum issued by the government of India for issuance of economically weaker section certificate, page number 2, which deals with these things. That is in para 4, criteria of incomes and assets. In order to obtain an economically weaker section certificate, a person will have to fulfill these things. First, it says persons who are not covered under the scheme of reservation for SCs, STs and OBCs and whose family has gross annual income of 8 lakh rupees are to be identified as EWS for the benefit of reservation. Income shall also include income from all sources, that is salary, agriculture, business, profession, etc. for the financial year prior to the year of application. Now, thereafter, all these details are given, which are there in their website as well. There's that land, income, everything. Now, admittedly, I have obtained an annual income certificate from the authority concerned. That is the Andaman Nicobar administration only. And thereafter, I applied for one EWS certificate because I'm in general category because if I am in, I am a OBC, SC or ST, I am not entitled. So I am an islander, I am in general category and I'm a poor person who doesn't have 8 lakhs income annually. To that effect, I have an X certificate. And regarding my address and everything, I have already clarified, my lord.
And what about the appeal?
My lord, again, my lord may kindly come to the ration card, my lord.
Yes.
It's of date has not been mentioned. I think it's 2020.
2020.
13th of
4 years earlier to my 4 years earlier to my application.
At the time,
And I am the most fittest person to be given a
residence, my lord, address may be seen, it's Kolingpur in 2020. Thereafter, my lord, the income certificate, which he has applied for by filing an affidavit. In that, my lord, in 2022, he has submitted one affidavit for some correction of names and all. Is written it's Shadipur.
That was my correspondence address at this point of time, which is my teacher's address, clearly mentioned. Care of. That cannot be used as an address proof, my lord.
2020.
Would they accept that as an address proof?
No, addresses, 3-4 addresses are there. Which one to we will accept it?
Accept an affidavit as an address proof, my lord. Or they will accept my ration card.
I'll show
or
the
voter ID.
certificate.
The things they cannot accept.
Should it be decided by the High Court?
That is the
This has
question.
not, this has not to
These
be decided by
things
the.
cannot be
I could-
decided.
All I am on is that the 103rd amendment to the Constitution of India, wherein Article 15, subclause 6 and 16, subclause 6 was inserted. The intent of that particular amendment may kindly be seen. The intent of that amendment is to extend certain benefits to the real economically weaker section of the society, and I am one of them. Admittedly. And yet the disputes.
My lord, on instruction, I'm submitting, my lord, what the Tehsildar has submitted on the last occasion also. This mismatch of documents, the father's name and the address are not matched with the documents, my lord, what he has submitted. And secondly, my lord, the islander identity card, which is a mandatory document to be submitted at the time of applying for the EWL, that he has not submitted that document. These are the things. So
My
for
lord,
that reason
apart-
only, his application was not considered.
And apart from that, the Honorable Apex Court has given certain guidelines for issuance of EWS certificate. In Kumari Madhuri Patil versus Additional Commissioner, it is a judgment from September 2nd, 1994. Page number 11 deals with that. That may kindly be placed. If I have given anything false, or if I have sworn in false affidavit, or, and moreover, my lord, this particular document is issued for 1 year only. If, page number 11, from page number 11 it starts. If I am found, I mean, the authority concerned can very well go to the place and verify everything, all the details. And if any of the details or affidavit sworn by me is found
Area
to be
Revenue's
incorrect,
field staff has verified, my lord, and it was found that he is not a resident of Kolimpur
did
village.
they mention as to whom did they ask?
And,
That report is,
That's a very vague and
my lord,
they can
report
do
is there,
anything.
my lord. It is not on record, my lord.
My lord, only on 1st August 2025, after coming before this honorable court, they have given that report. That cannot be believed.
This is the report. On the last occasion, I have handed over, but I took it back.
and the
If my lord sees the second page, my lord.
copy has been served upon him.
Yes, yes, I
Yes,
did.
yes.
Even I was
Last-
reading through that.
My lord, may kindly see the next page. my lord.
Next page.
Next page, second para. Further, field inquiry received from the area revenue field staff. It reveals that the petitioner is not a resident of Kolimpur village. Moreover, the documents are mismatched with the name of the petitioner.
Completely incorrect report, my lord. I am disputing this. Why did not they mention this while rejecting my application, my lord?
The report will
They did not
come
mention it only after
that,
coming before this
I'm
honorable, they mentioned
filing
it.
is the incorrect and whatever he is filing is the correct.
But then, it has to be reserved. Rather advocate for the petitioner, rather than advocate for the respondent. Hearing concluded and will reserved.
My lord, is fixed again. It is reserved.
Reserved.
My lord,
Mine,
obliged.
obliged.
I'm grateful, ma'am. I'm grateful.
I appear for the petitioner.
I appear for the respondents, my lord.
Your Lordship, the petitioner happens to be a businesswoman. She has set up a workshop of servicing center as well as repairing center of two-wheeler and four-wheeler at Karnikobar. Now she's operating this workshop from 2005. This period is very crucial, Your Lordship. 2005, why I am saying so, because our Andaman Nicobar Islands has hit tsunami in the month of December 2004. So from 2005, when there was a huge devastation, there was none to go to Karnikobar for any work. At that time, this particular petitioner, she has used her employees there to repair the vehicles which were in a very damaged state. So she started to operate from 2005. Now, at that time, the administration has allowed her to set up the workshop by allowing to use the tribal pass. Here, Your Lordship, the Nicobar is a restricted area. Nicobar is populated with Nicobaris who have been considered as a tribe. However, the administration from the very past many years, they started to bring all those tribes into mainstream. Now we can find these Nicobaris are holding very good position as a doctor, as a.
What is this impugned order dated 25th of July?
Yes, I'll come to that, Your Lordship. I just wanted to say what is the narration behind this. Now, this unit is working since 2005 there. Now, to enter those premises, one is required to obtain a necessary pass from the Deputy Commissioner. Now, all along, they were using the pass from the Deputy Commissioner. Deputy Commissioner looks at whether he is having a good background or not, whether any criminal and antecedents are there or not. So considering those, only passes are being given. Now everybody whoever are not tribal are working there with the pass as on today. Now what has happened? Exercising those passes, Your Lordship, the administration, many departments have allotted them tender also. Not only that, she has participated in the tender of the Deputy Commissioner's office also. So they also had given her tender to repair the vehicles of two-wheeler, four-wheeler, whatever. And moreover, this is the only unit for the entire Car Nicobar. So now what has happened? All of a sudden, this impugned order was passed. By passing this order, the officer concerned, who is not even authorized to pass such an order, he has straight away given 15 days time to obtain the necessary permission. And Your Lordship knows to obtain a permission from a higher authority, how much time it takes. Being the administration a welfare state ought to have given sufficient time to obtain the necessary permission as in terms of Section 6 of PAT regulation. If Your Lordship is having PAT regulation, I would refer Your Lordship to that. PAT regulation, Teacher. Now, Your Lordship, he is not authorized to pass such an order. My first limb of argument is that he is not authorized to pass such an order. And secondly, this order has been passed in a haste manner without affording any opportunity. Now, Your Lordship may kindly come to Section 6, which they have relied. If I read the language which they have passed, that impugned order which appears at, I'll just read, Your Lordship. The case was taken up today. Shri P. Satyanarayan, son of such and such, appear on behalf of so and so. During the proceeding, Satyanarayan admitted that the workshop named Satya Auto Service engaged in repair services, rented and sale of 2, 4 and 6 wheeled vehicles is being operated from the premises rented from Srimati so-and-so, a tribal resident of Car Nicobar at a monthly rent of rupees such and such, which are paid by the proprietor. The following facts were submitted and verified. Shri Satyanarayan is a permanent resident of Vijayapuram and the business operations are entirely managed by hired staff while his presence in Car Nicobar is minimal. The shop is registered under the ANN Shops and Establishment Rules. This is also very important. 2005 and has a GST registration under the name of so-and-so. Around 16 staff are employed at the unit, all holding valid tribal pass till 31/8/2025. The operation of commercial unit on a tribal land without due regulatory compliance and restrictions constituted a violation of Section 6 of the PAT Regulation 1956 and other applicable commercial laws. The operation of Satya Auto Service will be ceased after 15 days if the proper registration not obtained under the Shop and Establishment Rules 2005 and other mandatory provisions in accordance to the Section of 6 of PAT Regulation. Now, sufficient time would have been given, Your Lordship. In a very haste manner, this order has been passed. Now, I am taking Your Lordship to Section 6. He is not, Lordship,
of the PAT regulation.
PAT Regulation. Now, they were supposed to act in some other manner, but though this officer is not an authorized officer to pass such an order, but still I will take Your Lordship. Got it, Your Lordship? Page 3, Section 6, subclause 1.
Page 3 of what?
Of PAT Regulation. I will mark and give you.
Following regulations.
6. No person other than.
No person other than.
No person other than a member of aboriginal tribe shall, except with the previous sanction of the Chief Commissioner, here the Chief Commissioner is Honorable Lieutenant Governor, acquire any interest in any land situated in a reserved area or in any product of or crop raised on such land, or shall accept under and in accordance with the terms and condition of a license granted by the Chief Commissioner, carry on any trade or business in such area. So there are two things, tribal pass, and this is the necessary permission which is required. Now, all along, they were not insisting for this permission, and they themselves has allotted me with the tender to operate from there, which goes to show that it was not that very mandatory as required. Anyhow, if they were requiring this, they would have given me sufficient time. Now, what is the, if I flout this, what is the result? Lordship may kindly come to section 8. 8.1. Whoever, in contravention of the provisions of section 6, acquires any interest or in any product of or crop raised on any land or carries on any trade or business in a reserved area shall be punished with imprisonment which may extend to 1 year, or with fine which extend to 1,000 rupees, or with both. So this is the imposition. But they have chosen to shut down the unit itself. So this is where I am before this honorable court. Now, tribal council who is operating for the tribal people, they themselves have written letter to Honorable Lieutenant Governor requesting the person concerned to operate from that place, because that is the only unit which is functioning from there. And I have taken tender of government organization which is operative, still in operational. So how I am going to work? When the government himself has given me tender, exercising the pass which I am carrying, now at this stage they are asking me in a haste manner, you close down within 15 days. It is an arbitrary action and he is not authorized to do it.
And this order was issued by
This was
Yes,
issued by
yes.
Assistant Commissioner.
Assistant Commissioner.
And all other Chief Commissioner is required to give me permission, and Deputy Commissioner is required to give me tribal pass. He is not an officer concerned here to deal with all such things. And surprisingly, Your Lordship, the tribal people have themselves have written a letter to the Lieutenant Governor.
So no consequence.
That's right, Your Lordship. Lordship may kindly, I did not wanted to pinpoint those, but I'm forced to. Lordship may kindly come to my supplementary affidavit, which I have relied. The reason behind for closing down in a haste manner is being stated. Page 13.
13 of the
Supplementary affidavit, annexion S2. 5, paragraph 5 may kindly be seen.
Paperwork collection of material and
It's an open letter written to the. So what I propose, pray for, before this honorable court to kindly stall this order.
Madam,
The letter which my lord has just seen. My lord has seen who has
Yes,
written
that's
this
right.
letter.
It's an open letter. It's an open letter. It's not that.
Whether this matter will be in a politically oriented matter or what? My lord has
He's the
seen this
present,
letter,
present MP.
page 12, 13.
He's a serving MP.
Who has written how he is aggrieved by those orders.
He is
And
the
this
people's
not-
representative.
Not just she may finish first.
Yes,
Then I
yes, I have finished actually.
he is interrupting. My lord has just seen the letter. Just my learned sister has shown who has written this letter. This matter, it's of tribal, it's the entire Nicobar district is a tribal place, my lord. And if my lord sees section 6 of PAT regulation, my lord, it is very clear. My lord may kindly see again. Section 6. No, it starts like this, my lord. No person other than a member of an aboriginal tribes shall it is there, mandatory, except with the previous sanction of the chief commissioner, acquire any interest in any land situated in a reserved area. And this Nicobar district, my lord, is a reserved area for tribals. It's a tribal area. Or in any product of or crop raised on such land, or shall, except under in accordance with the terms and conditions of a license granted by the chief commissioner, carry on any trade or business in any such area. Second, my lord. Second is not. Then, my lord, 8,
That she has placed
the penalty.
penalty.
8, section 8.
And by this impugn order, what penalty you are?
And this is not the writ petitioner, is the not the loan person, it's all the shopkeepers. And they were granted, even they approached before the authority, my lord, authority has granted time for them to obtain necessary license. So, my lord, this writ petitioner, instead of approaching the authority, my lord, he has approached this honorable court.
What about point number 2 in the impugn order,
My lord.
failure to comply?
Failure to comply shall result in sealing of the shop premises, seizure of commercial goods, and legal proceedings under the PAT regulation and other applicable laws.
And where are those regulations? Where are those regulations? Sealing, which authorizes sealing.
The penalty, my lord?
Penalty
8.
is 8.
8, my lord.
It doesn't contemplate of sealing.
Yes, punishable with imprisonment or penalty amount.
Where is the sealing? How can you seal?
Sealing, it will come under other applicable commercial laws, my lord, that I have to check because it is there. If he is running a business, my lord, without a valid license, then obviously it has to be sealed.
Punishment has been
In
provided
PAT
for.
regulation and other applicable laws. If my lord sees that number 2, my lord, under the PAT regulation and other applicable laws.
But your order says other mandatory provisions in accordance with section 6 of PAT regulations 1956. No other law has been mentioned.
In 2, my lord.
Huh?
Failure to comply shall result in sealing of the shop
PAT
premises.
regulation 1956.
6 and other applicable laws. Applicable laws means commercial laws.
What are those?
Under commercial laws, if without license, if I am carrying out any business, so if I find that it's not it's running without a valid license, then there's a provision for sealing of that business, my lord.
License is depicted in page 70,
17 of
17 of writ petition. Udyam registration certificate. Second one is GST registration. GST registration will not be done merely. I have to follow certain things. This is a registration and GST certificate.
Udyam registration certificate.
Industry. The idea was imposing this punishment and this was your lordship
Total
given
53 shopkeepers
sufficient
are there,
time.
my lord. Total 53 shop rooms are there and 28 have been issued with this order. Same order.
So the question,
28 shopkeepers were issued with the same order, my lord. And they have approached before the authority concerned and they were granted further time, my lord. Because we are not saying that we will stop them from running their business.
no, I cannot.
Still continuing with the business.
You will file.
Whether
You
my
will file affidavits in the writ petition.
it is required then, my lord, because
You have to.
yes, I'll file my affidavits, my lord. Because he is not the
I'm
one person.
insisting for an entry in stay, your lordship, because I have taken government tender.
Petition.
The very department himself has given me a tender.
Have been filed. By the, at the behest of. The company. Challenging the. Order. Order dated July 25, 2025. At page 50
Yes,
of your
impugned order, your lordship.
MPU order,
Impugned order appears at page, just
Page 50, my lord.
50. Yes, 50.
sorry, next paragraph, by the impugned order, the writ petitioner has been directed to obtain a certificate in terms of PAT regulation.
Pat regulation.
In terms of PAT regulations within 15 days from issuance of such order. Stop here. No. No. I've been directed to obtain certificate, registration certificate of registration. Under the Shops and Establishment Rules 2005. And together with other mandatory provisions in accordance with Section 6 of the PAT Regulations Act. Other mandatory provisions in accordance with Section 6 of PAT Regulations 1956. The order impugned states that in case of failure in obtaining the necessary certificate within the time frame, the shop and establishment belonging to the writ petitioner shall be sealed. It is submitted on behalf of the advocate for the petitioner that the petitioner has been running an automobile company. Automobile
Repair shop.
repairing shop. At Nicobar Islands.
At Nicobar.
At Nicobar Islands. For a long period of time. Study. Has also been awarded with several government tenders by the authorities. So therefore,
Which is still active.
the tenders.
Tenders are active.
According to petition, the aforesaid, tenders are still active and the petitioner is working with the work assigned under such tenders. So it is also submitted on behalf of on behalf of the petitioner that the time period fixed by the impugned order for obtaining a license as contemplated therein is too short. However, she claims that the petitioner has never violated the provisions of the PACT regulations during the continuance of her automobile repairing shop. So the next paragraph will go to on the other hand, next advocate appearing for the respondent authorities submits that the petitioner has been directed to obtain a certificate in terms of the regulation, PAT regulations. Stop the learned advocate for the respondent also submits that the instant writ application filed by the petitioner is misdirected one. Stop here. Out of 56 shop rooms.
56 were given this, or 28 I have the list, my lord. But they're saying on instruction I'm submitting altogether 56 or 58 shop rooms, they will be given with the same notice.
56 shop rooms, 28 have been issued with
Even
similar,
same order, same order, same date.
Stop the such persons approach the authorities and their time to obtain the certificate has been extended by the authority. Stop the petitioner ought to have approached.
I have already approached.
They are saying.
No, they're saying,
They are saying.
on instruction I'm submitting, my lord, they're saying that no petitioner has not approached them.
No.
All others have approached, they were granted for the time.
Okay, it is her contention.
It is their submission that a petitioner ought to have approached the authorities for such extension. So heard the rival contentions. The usual of the mechanism, a record as well as the relevant provisions of the draft regulation. It transpires that it is not in dispute that the writ petitioner has been running the automobile repairing shop in Nicobar Islands since long. So it is also not disputed that the petitioner has been associated with government works at in the islands and have been awarded with government tenders under which he has been carrying his works. Stop the by the impugned order dated July 23. But the writ petition prayer says 25th of July. And July 20.
The order, I think.
It was issued on 23rd.
23rd, order dated 23rd July 2025.
Yes. July 23, 2025. By the order July 25. The writ petition was directed to obtain a certificate under the Shops and Establishment Act as well as PACT regulations within 15 days from the issuance of such a letter. Stop the considering the submission made on behalf of the respondent that other persons issued with similar directions approached the authorities and their time to obtain such certificate was extended by the the authorities. Uh, hmm, sorry. Stubby and next para in such circumstances, the operation of the impugned order is stayed for a period until,
Let us can say until next circuit you mentioned. Or until the final decision is taken by the.
No, 2 weeks.
you have to apply.
Okay, I have
Have you
applied
applied?
already.
You have
We
to,
have already applied.
2 weeks.
until, this is August, until August 31, 2025.
Next circuit is a.
Next circuit, on by 21st, I think.
25th.
25th.
25th. Right.
Stop
25th of August. Next circumstance.
In the mean, the respondents shall file their affidavit in opposition
In opposition within 2 weeks.
2 weeks.
within 2 weeks from date. Reply if any within
1 week.
1 week thereafter. List the matter before the next available circuit.
Much of.
Stay up to 31st.
1st of August. My first of next.
I'm for the petitioner, your lordship. I kindly pray for not today.
Not today.
Yes.
What is the matter about? Madam was there.
Your Lordship, I am appearing, Your Lordship, through VC.
Yes, madam.
Your Lordship, this is the same matter, Your Lordship. It is relating to the noise pollution. Your Lordship, conditional order was passed by the subdivisional magistrate, and I wanted, Your Lordship, because that is only a initiation of the proceeding when order has been passed. I just pray, Your Lordship, that the matter should be concluded. They have not challenged that order anywhere.
You have not challenged the order, conditional order. This is dated 29th of December. This is just to close the doors and cover the walls with proof material to ensure the sound is well, ensure the mixing doesn't cause any.
कुछ कांड किया ना वहां जाके तो दबा दिया लगता है तभी तो इंडिविजुअल बोलती है वो
They have,
कौन सा मैटर चल रहा है
they have not yet,
कौन सा मैटर चल रहा है अनम्यूट कर दिया करके चले गए
हम लोग लास्ट मैच है दीदी
33. This one failed to comply with the order. 133, madam. Is it
Your
amenable?
Lordship,
Is it amenable to read jurisdiction?
no, I am not challenging the order. I am not challenging the order. I am saying the
Your-
subdivisional magistrate has
No.
not
The process
complete.
be concluded at an early date. That is what you want.
Your Lordship, the voice is very less. I'm not able to hear, Your Lordship.
Your junior is asking for not today and keeping it tomorrow,
Your Lordship, yes, Your Lordship. I'll make submission tomorrow.
not today.
Obliged.
I'm hearing for the petitioner, your lordship. Item number 5, 6, 7, 8, 9, 12, and 14. All are similar matters, your lordship. The issue here is with regard to the petitioner being aggrieved by the impugned order wherein the objection of the petitioner was rejected by the VAT commissioner. And similar matter was placed before the learned court number 1, and we have got an interim order. So I would pray that similar order be passed by this one. All are same
Who
matter.
is opposing?
But I'm opposing, but don't think the order has been enclosed here. Right.
Page number 42. The impugned order.
Page number 42, limit to the storage, rest of the application must be. In view of the above observation at page 45, the notice of this assessment issued under are hereby upheld thus.
My copy, it was not that long, that's why.
This is the impugned order.
Your Lordship, page number 42.
Page number 42, operating portion at page number
Operating portion is
45.
45.
Notices of assessment issued under 32 and 33 are hereby upheld. Operation is hereby dismissed. The petitioner discharge their liability within 15 days of service of the conclusion of that tax to guide the petitioner in competition of tax interest.
Your Lordship, therein, there are various dealers who are registered under the value added tax regulation. On all those dealers, there were certain notice of assessment and penalty issued. After that, we filed our objection. The objection was rejected.
Rejected.
But the forum where we can challenge this objection is appellate tribunal as per the regulation. That appellate tribunal is inexistent. They have not even constituted that. And secondly, we have approached under writ jurisdiction because of two things. First is the initial notices which were issued for assessment and penalty. Before that, there was no audit carried out, which is a mandatory requirement. That means no opportunity of hearing was given. Secondly, when a notice of assessment and penalty is issued, it has to be issued within the limitation period. When the limitation exceeds, that means the commissioner has exceeded the jurisdiction. So considering this, learned coordinate bench of this court has passed an order wherein, as considering that this issue is already in session, increasing that, Your Lordship.
And
An interim order was granted.
you want the same interim?
Full interim order, Your Lordship. Because in all these matters, the impugned orders are the same.
Sin of the matter, let there be an interim minister. Which court is in session of the matter? The appellate court.
No, no, sir, court number 1.
Version filed within 2 weeks from date, affidavit within since the court is in session.
The respondents require time to file their affidavit in opposition. So here also they will be requesting for the same.
There is have any objection to in passing this order?
Impugn order is same in nature. Impugn order is same in nature.
Because he order. This is also order of the joint commissioner is dated 22nd.
Yes, it's
It is 22nd of July.
same date, same date.
Same date. Same orders passed in 5, 6,
5, 6, 7, 8, 9, 12, and 14. 5, 6, 7, 8, 9, 12, and 14.
12, 14. And that is that has been this matter shall be 7 minutes. And when the date is you will that clear. You want affidavit directions,
Same.
Same.
That order also affidavit direction has been given.
but
Obliged, Your Lord.
एक है अच्छा शाबाश और হ্যাঁ নেক্সট উইকে যাবে দেবে তিন পজিশন দেবে তারপরে তার রিপ্লাই আসবে ওই অর্ডারটা আছে
petition is pending before the authority, within certain time, they can be.
And for autonomy. That's it.
The project payment, they have filed an application before the authority.
Commandant dispose of representation. Dated by subdivision, dividing the land.
Page 23. Subdivision of my land, have applied for. with the
That has not
consent
been
of-
decided.
That has not been disposed of.
Sir?
So several applications, several notices are issued. I'm appearing each and every day, but the final order has not been passed.
Yes.
Subdivision matter has to be completed within 60 days. The citizen chapter six mentions within 60 days it has to be completed. I have given in the month of November 2024, still it is pending.
Yes, sir.
I got the copy today, no, I also.
Subdivision from consideration.
That is representative consent apology.
Read be disposed of in terms of the directions.
In terms of the.
The instant writ application has been filed by a citizen who is seeking a direction upon the respondent authorities. Respondent number two. Respondent number two to dispose of representation dated November 12, 2024. With respect to subdivision of the landed properties belonging to the writ petitioner. So the next paragraph it is submitted on behalf of landed advocate for the petitioner that the writ petitioner is a joint recorded tenant in respect of lands bearing survey number 123/2 and 47/1. Measuring an area of 0.0775 and 0.0460 hectares respectively, and situated at Richganj village. So the writ petitioner as well as the other co-owners entered into a family settlement and executed a family settlement deed on September 6, 2024, amicably deciding the partition of the joint family properties. Decided the partition of the joint properties. Stop the person to such settlement, the writ petitioner applied before respondent number 2 for subdivision and some subdivision of the land by an application dated November 12, 2024. Stop the according to learned advocate for the petitioner, writ petitioner, the such application, in terms of the prevalent laws, is required to be decided within 60 days of the application, but the application filed on behalf of the writ petitioner is yet to be decided by respondent number 2. Next paragraph. What will be your submission?
I say that the status of the present was
that
Those notices were issued, Milord, for
That will
proceeding has been initiated. It was 26 May.
on the other hand, I advocate for the appearing for the respondents submit that proceeding has been initiated,
Notices
but-
have been issued.
but notices have been issued to the respective parties, but it is yet to be finally decided. So the next paragraph, having considered the survival contentions and perusal of the materials and record. Come on this court. Is inclined to dispose of the instant rate application at this stage itself by directing the respondent authorities, specifically respondent number 2, to dispose of the application filed on behalf of the writ petitioner dated November 12, 2024, in respect of partition or
Subdivision.
in respect of subdivision of the joint properties within
Proceeding has to be initiated, the maps has to be verified.
within 2 months from date. Anything else?
Has to be in accordance with the existing provisions.
Within 2 months from date, in accordance with law. Study. It is needless to say that in doing so, the respondent number 2 shall afford a reasonable opportunity to be heard to all the parties. He is at liberty to consult such documents as the respondent authorities deem fit. That's all.
As no affidavits call for the allegation content.
No affidavits, since no affidavits were called for from the allegations contained in the writ petition shall be deemed to have been denied. So the writ petition is disposed of.
Fine.
Learned advocate for the petitioner submits that the service upon the respondent is yet to be effected. Could be in such circumstances. But list the petition before the next available circuit. The respondent is
Not a guide.
next circuit.
Very nice. Where regarding the disposal of the mutation application filed by is pending before the.
Which
My lord.
authority?
My lordship, I am for the respondent, my lordship, led by Mr. V.D. Shivbala. Let it be disposed, my lordship. There is a direction, they are seeking direction for disposal of their application for mutation, which is pending.
Number 33 annexure PC.
Page number 33 is your application.
Yes, my application.
Aadhaar card da
Is pertaining to be. And furthermore, my lord, another person has also filed an application for mutation of the same property. So if they have those things.
In accordance with law, it can be disposed.
Which matter?
Pertaining to the same revenue case.
Another revenue case was also initiated pertaining to the same property for the same person mutation.
Where is the writ petition, sir?
Yes, no, in the repetition itself, it is at page number
You,
28. Annexure people.
this is the writ petition by Ruxana
Yes,
Khatuna.
She had applied, my lord, the facts of the case was as such, my lord. The sister of the petitioner had explained. She is the joint recorded tenant of the property.
Oh, that will be seen in accordance with law.
Yes, ma'am, this application.
Yeah. Instant writ application has been filed by citizen study. It has been submitted by learned advocate for the petitioner that father of the petitioner was a recorded tenant in respect of land bearing survey number 14/1/1, comma 29, comma 34, measuring an area of 0.6192 hectares, comma 2.55 hectares and 0.68 hectares respectively, situated at Danapur village under Mayabandar Tehsil. Dost Mohammed was your father.
Those Mohammed is not.
The father of the petitioner, namely one Dost Mohammed, expired on May 29, 2010. Sabdi, after his demise, the properties were duly mutated in the name of the petitioner and 7 others. And your mother has now expired.
No, the sister has expired. Janati.
The petitioners for the submit that the rate petitioner and others brought a title suit in respect of the properties, being title suit number 3 of 2022. In such title suit, a preliminary decree, it was a partition suit.
But
Preliminary decree was passed and share of all the share of all the co-sharers, including the writ petitioner, was declared. Later on, where have you pleaded that as our petition? In terms of the directions in the preliminary decree, the joint owners partition the property in dispute by meets and bounds amicably. That
we had an application before the authorities. We had made an application before the authorities.
the petitioner and the other legal heirs have partitioned the aforesaid landed properties by meets and bounds, para 7, amicably in terms of the preliminary decree, and prepared a proposal map.
But subsequently,
That was placed.
Yes.
That was placed.
Yes.
In terms of the preliminary degree, a map was prepared, which was submitted before the authorities for finalization. Um, mm, so it is further submitted by by the petitioner that one of the sisters of the the petitioner, namely late Jannat Bibi, expired, leaving behind the petitioner as her legal heir. So however, one Sri Ratan Paul, RATA, applied for mutation of his name in respect of the properties left by said Jannat Bibi. That is the dispute. Could be. Um, the authorities are yet to decide on such application for mutation.
At one point that we had also applied for mutation of the journal.
Right. Applied for mutation. Stop the writ petitioner, the comma being legal heir of late Jannat Bibi, also applied for mutation of the share of said deceased Jannat Bibi in favor of the writ petitioner. Stop such arrival claim for mutation in respect of the share of late Jannat Bibi is yet to be decided by the authorities. So have you started anything?
And that's it.
Have you started anything? Any proceeding for mutation? You
I have not taken instruction.
You have no instruction.
Yes.
This has been issued by the.
Notice has been issued.
This has been issued.
Learned advocate, next matter, learned advocate for the respondent submits that proceeding in respect of the disposal of the applications for mutation of the landed landed share of late General Baby has been initiated. Stop notices were issued to respective parties. Stop next paragraph. When did you apply, sir?
Page number 10.
apply करना मुझे
next para, in view of the above contentions made on behalf of the parties and on consideration of the materials on the board, it would be appropriate to dispose of the constant writ application by directing the respondent authorities, more specifically respondent number 2, to dispose of the applications in respect of mutation to the share belonging to late Jannat Bibi. To dispose of political. No, it would be appropriate to direct. It would be appropriate to direct. Right? তারপর শেষে চলে যান Jannat Bibi in accordance with the law within a period of 2 weeks.
8 weeks, my lords.
Huh?
8 weeks, my lords.
Within a period of 2 months.
Yes, my lords.
One clarity, that both the applications may be taken together and disposed of, or else they contradict to each other.
I said applications.
Yes, that is.
Uh, applications in respect of
Application filed by
mutation.
the writ petitioner and the.
Uh, the- so in doing so, the respondent number 2 shall provide the writ petitioner an opportunity of being heard. Stop here. In addition, respondent number 2 shall be at liberty to hear any other party or consult any other document as he deems fit. That's all.
Yes, my concern.
The petition is.
My lordship, since AO is not filed,
Huh?
since affidavit in opposition has not been filed,
Just,
all the allegation may be deemed denied.
deemed to be denied.
Yes, my lords. Obliged, my lords.
Your 45 or 125. Now I'm for the number 3. I'm finding my marker.
And who is for the petitioner?
Appearing for the petitioner, your lordship.
I'm there for 1.
Respondent number 1.
I'm for opposite party number 7. Radisha Vipu.
Whereas the other opposite parties are concerned, your lordship, the affidavit of service has been filed. They are not appearing before the learned first appellate court as well. It is sitting next.
Opposite party number 3.
Opposite party number 3.
I'm at it.
Opposite party number 3 is present here, and opposite party number 7 is present here. They are appearing before the trial, learned first appellate court as well. Whereas the other respondents are concerned, they are not appearing there.
They did not appear.
Next party as a even they are not appearing here. The
What,
affidavit of service has been filed.
Sir,
They have been served.
no, sir. Item transmitted to Calcutta BO. What is the matter about?
Your lordship, the issue here is with regard to service upon the respondent number 1, only upon the respondent number 1. What has happened is the petitioner herein, being the appellant there, had served the respondent number 1 through the way of ordinary manner as per order 5. When the summons report came, the report of the process server indicated that as the respondent number 1 has gone out for work and it is uncertain as to when she will return back, therefore the summon could not be served. That was, he ascertained that by asking from a neighboring person.
And respondent number 1 is appearing.
Respondent number 1 is not appearing, but the summons has been, the notice has been served. Here also what has happened, your lordship, the respondent number 1 has avoided service because the report may be seen, tracking report, the addressee has directed to deposit. And even after that, the addressee has not collected the notice which has been sent. And here also the respondent number 1 is avoiding. The same manner as it was done for the learned first appellate.
And what was directed by the
What
trial
has
court?
happened, your lordship, after I served through ordinary way, the summons report came in such a manner, I served through speed post. When I served through speed post, the item was delivered to the addressee.
Even then you were directed to
That
serve
was,
again.
your lordship, that was, the tracking report was submitted to the learned first appellate court. The court did not consider it as a good service. That is one of the impugned order. Secondly, the only option after that left with me is to file an application under Order 5 Rule 21A for newspaper publication. I filed that application. When I filed that application has been considered as premature and it is kept in abeyance, and the court has directed me to again serve in ordinary manner. Page 34, your lordship. Page 34 may be seen. Item delivered to the address.
which is the portion of the order by which you are agreed?
Your Lordship.
The present as, why those-
First impugned order is page number 37.
Professor will put that.
Page number 37, second paragraph. I may be allowed to place that. Page number 37, the second paragraph. In the light the above fact and on perusal of the postal report, track report and report of the process server, it transpires to this court that the notice has not been served to the respondent, number one, as yet, and on the basis of track report, it cannot be considered as good amount of service. The Lordship, order 5 specifically mentions under rule 9 that speed post is also a manner in which notice can be served. Summons can be served. The next impugned order is, Your Lordship, page number 40. Page number 40, where I find an
By
application.
37, you were directed to serve again upon the opposite party.
Again, I was directed to take necessary steps. So I took necessary steps on the next occasion by filing an application under Order 5 Rule 20, 1A, for publishing in daily newspaper. That impugned order is page number 40.
Accordingly, citizen filed an application under order 5 rule 20 of the city, and he submitted that from process server report that is not at her house with process server went to serve the summons as she went over. He also submitted that some postal receipt and track report that the item was delivered.
My application was considered as premature and I was asked to submit it again in ordinary manner.
Many of two grounds. And
Who are you?
I'm the opposite party number 7.
And what you have to say on this
Well,
point?
I have many things to say, but I will say two things which is very important. First of all, this is an application under Article 227. I have not brought that judgment of the Supreme Court which says Article 227 cannot be exercised sparingly. If the court's conscience is
1 to 20.
judicial conscience must be shaken. But not the impugned order nowhere affects the rights of the party. Their order 5 rule 21A application is kept pending. No decision has been taken. If it is not taken, why 227? That's first point. Secondly, order 5 rule 21A, capital A, provides the substituted service of summons. But to get an order from any civil court, a compliance of order 5 rule 17 is mandated. Now just read these two provisions. Now I have got 3 judges judgment of Supreme Court by Justice Mishra, Deepak Mishra, Manmalikar and D.Y. Chandrachud. Order 5 rule 20 would come into play provided order 5 rule 17 is complied with. So kindly have a look to order 5 rule 17. Thing is very simple, Lord. Thing is very simple. But since they have approached before this court, I have a right to place these facts based on law. So kindly see order 5 rule 17.
By this time, they could have complied.
Absolutely. I'll come other materials also, Lordship. How the things have been moved out, I'll just show you. No, kindly come to order 5 rule 17.
Hey, again. छोटी कोई नहीं
Left half connection.
I don't know. No, that is criminal CRPC. Other
5 rule 17. No, I'm just reading order 5 rule 17. Procedures when defendant refuse to accept service or cannot be from. These are the two sine qua non, where the defendant or his agent or such other person as aforesaid refuse to sign the acknowledgement, or where the serving officers after using all due diligence and reasonable diligence cannot find the defendant who is absent from his residence at the time when the service is thought to be effected on him at his residence, and there is no likelihood of being found at the residence within a reasonable time, and there is no agent empowered to accept service of summons in this behalf, nor any other person on whom service can be made, the serving officer shall affix a copy of the summons on the outer door or some other conspicuous part of the house in which the defendant ordinarily resides or carry on business or personally works for gain, and shall then return original to court from which it was issued with a report endorsed thereon annexed thereto, stating that he has so affixed the copy, the circumstances under which he did so, and the name and address of the person, if any, by whom the house was identified and whose presence the copy was affixed. So the pasting in the conspicuous part is a mandate.
And this was not complied.
Not done. Now coming further, note. I'll come further. If this is complied with, then Order 5 Rule 20 comes into play. This judgment of the Honorable Supreme Court by 3 judges may kindly be considered. I'll just place. And then I'll take notes of the material on record of the revision application. Now this is paragraph 14. 14 and 15 of this judgment. This is reported in the 2018 Volume 2 Supreme Court Cases 649. In the case of Nirja Realtors Private Limited versus Janglu Debts through Legal Representative, paragraph 14 and 15. When the application for substituted service was filed before the trial court under Order 5 Rule 20 of CPC, a cryptic order was passed. Substituted service under Order 5 Rule 20 of CPC is an exception to normal mode of service. For such service, Order 5 Rule 20 of CPC requires the court to be satisfied either that there is a reason to believe that defendant is keeping out of the way for the purpose of avoiding service, or that for any other reasons the summons cannot be served in ordinary way. That the court must apply its mind to the requirement of Order 5 Rule 20 and its order must indicate due consideration of the provisions contained in it. Evidently, the trial court failed to apply its mind. Then not straightaway to paragraph 15. The submission that Order 5 Rule 20 is not necessary to affix a copy of summons at the house, and at the house where the defendant is not known to have decided once quoted directive publications really begs question. There was a clear breach of prescribed procedure under Order 5 Rule 17, even antecedent thereto. Besides, the order of the court does not. So these are the settled proposition of law. Not so. First of all, the court have not considered Order 5 Rule 20. Application is kept pending. Rights have not been affected. If it is not done, no civil division. Secondly, there is a non-compliance of Order 5 Rule 70. Now kindly see the materials. Now, if they say
There are 15 and 16.
14 and 15.
14 and 15.
If they say, kindly see, they say that through postal service was effected. Kindly turns to page 33 and 34 once. But see, 33 is the postal slip. But see, this postal slip is contained from and to. Would find Port Blair headquarter, Port Blair ICJ hub to Port Blair ICJ hub. Now, this postal slip is not the slip. This is a slip which is affixed in the envelope. If I book a envelope, they would give a slip to me from my name to addressee. This slip is affixed in the envelope which is sent to the addressee. That's one thing.
The original receipt is not there.
Secondly, 34 track reports. Track reports indicate the corresponding consignment item delivered. Now, if they are saying that the item has been delivered, then why Order 5 Rule 20? They should have simply sought for ex parte hearing. Why Order 5 Rule 20? Now, Order 5 Rule 20 will come into play when the defendants evade service of summons, subject to compliance of Order 5 Rule 17 in line of the ratio as laid down by the Supreme Court, Order 5 Rule 20. When they of their own saying that the service is a valid service, then why Order 5 Rule 20? Meaning thereby service has not been affected. And also the court below committed no error. The application was kept pending. A chance was given to them to send it through both modes. One through process server and one through process again through court. And to that mode, in the envelope, the court would put their endorsement, official seal, from court to the addressee. That's the response number one. So Lord, I pray for rejection of this application. Let them adhere to what has been done by the court. The application is still by only these three grounds.
Respondent number 3. You have
the law point. I have no other people against you.
anything in reply?
Your Lordship. First of all, Your Lordship, with regard to maintainability of this arrangement, Your Lordship, there is a specific law point involved. Whether when a service is affected through speed post, whether it complies under Order 5 or not. Secondly, can Order 5 application be kept in abeyance and considered as premature? It has been kept in abeyance. And the most important thing here, Your Lordship, is to my application under Order 5 there was no objection filed by the respondent there. There was no objection. So can the objection be raised here when the objection has not been filed there? There was no objection filed. I have not raised any objection to my application. Now, Your Lordship, when the item has been delivered to the address, even the conduct of the respondent number 1 can be seen here. Even the notice was served to this court. On the direction of the respondent number 1, the respondent number 1 directed the postal person to deposit. It was deposited on the direction of the addressee. And
Yes, who is respondent number 1?
respondent number 1, Hamida Bibi.
Where is the postal receipts? Where are the postal receipts? Hmm.
Application had filed receipts.
Yes.
There are any correspondence to that receipt? This one is the. Now, Your Lord, whether Order 5 Rule 17 comes into play here or not, that has to be ascertained. Your Lordship, the difference in Order 5 Rule 17 and Order 5 Rule 20 has to be noted. Order 5 Rule 17 says that when defendant refuses to accept service, defendant has not yet refused or cannot be found, he is still residing in that area. Whereas Order 5 Rule 20 says then the defendant is avoiding service or through ordinary way if summons cannot be served. That difference has to be looked into, Your Lordship. Why Order 5 Rule 17? Order 5 Rule 17 cannot be a prerequisite mandatorily under Order 5 Rule 20 if the defendant is avoiding service. When the defendant will avoid service, in that case, or through ordinary way, if it cannot be served, how can Order 5 Rule 17 be complied with in that case? When I am serving through speed post, can the postman go and paste it? Can the postman go and paste it and comply with Order 5 Rule 17? Only the process server can do that.
That is why you have been asked to.
That is why because Order 5 Rule 9 gives an option, not just ordinary way. Through speed post also it can be served. I will be allowed to read the relevant provision.
That is there.
There's no debate. There's no debate.
That is there.
There's no argument on this.
When the item has been delivered already, in that case, the only option which is left with me is to file an application under Order 5 Rule 21A, that is substituted service. Because ordinary way, now Your Lordship, the thing here in it, what was there in the report of the processor, that has to be reprinted. Page number 20. I, Gopal Chandra Das, process server of this court, declared that on 12/11/2024, I received this notice for service. On 27/11/2024 at about 11:30 AM, I went to the address of the addressee at Kamraj Nagar there, near Anganwadi Center, Kamraj Nagar 1. He went to the address. I found that the addressee's front house door was locked. That does not come under the category that defendant refuses to accept service or cannot be found. He is found, his door was locked. Next, Your Lordship, then I inquired about addressing Hamida Bibi from her neighbor, Shri A.S. Roy. He told me that addressing Hamida Bibi has gone for work and she will return after sunset. So the notice was answered to the honorable court, with the above cited reasons. Second, whether she is a working lady, her examination in chief may be looked at. She is not a working lady. That clearly proves that she is avoiding service. She is not a working lady. Your
The
Lordship,
process server reported what he was reported.
Your Lordship. He inquired from a neighboring person. Now, this conduct of the respondent number 1 itself qualifies under Order 520 that the respondent number 1 is avoiding service, and second, through ordinary way,
Process server, after getting that report, should have affixed a copy of the notice at then and there,
Your Lordship,
and he should have reported this to the
that
court.
would have been done, and
That was not done, but that is why the impugned order has been passed.
But after that, I also filed summons to speed post. I filed summons to speed post. That was
With
also complied with. Your Lordship, when I have tried both the ways, again if I try, same report will come. This will be the same content because I have tried again through speed post as well. This will be the repeated conduct. Because Your Lordship, this is a partition suit.
In anticipation, you are taking the other way around.
Your Lordship,
That she will behave in the same manner. So it is better to serve.
if this is the report of the process server, if he is unable to serve, if the respondent is avoiding service in such a manner, Your Lordship, then in that case, what option do I have with me? I can do that by speed post. I have complied with that.
This time you persuade the process server to fix a copy of the notice upon his residence.
A condition be a noting be done if the process server is wasting, and even then, if the respondent is not complying with that, then I may have a right to file an application and order file.
No, not if
That is the law, sir.
No. Your Lordship, but
Why should I declare a law?
Your Lordship,
pasting would done in presence of two witnesses,
Your
and
Lordship,
that would be
first of all, Your
submitted
Lordship,
to below.
there was no objection raised to my application there.
So he is not entitled to raise objection here.
Of course, sir is entitled, Your Lordship, but objection ought to have been raised there as well. In that application, there was no objection raised.
So that this
Your
time
Lordship.
consumed
Your
could
Lordship,
have been avoided.
Your Lordship, but order 5 goods 17 will only be a prerequisite to order 520 when these two conditions are satisfied. Not in every
One of the
case.
conditions are already satisfied, that he was not found.
Your Lordship, he was not found.
He was not found, she was not found, sir.
Logged and not
As per
found.
the report of the neighbor, she was not found to be served.
Your Lordship, the door was locked. He is saying there, not found, Your Lordship, when the addressee does not reside there. Then the not found principle will apply, Your Lordship. Because then order 520, the notion of avoiding service will come here.
Not found has been elaborated in a 62 judgment. I would place that also.
Your Lordship,
Actually, not what would amount to not found.
Your Lordship,
If my brother argue more, I will rely more judgment.
Your Lordship, that citation has
Come
been
back
provided
tomorrow.
to me today.
No, at matter. I have concluded because not found, there are judgments. What would amount?
That citation has been provided to me today. Let me come tomorrow, Your Lordship, with the appropriate judgment.
He has borrowed Manod's word. Manod have said tomorrow. He is going back.
Your Lordship, the citation has been provided to me just now, while the submission was being made. I should get an opportunity
Yes,
to reply.
Absolutely.
And under what provision you get another day for replying?
Your Lordship, then this will be over, Your Lordship. I will.
Not today করে রাখুন এটা 15 ছিল না come back tomorrow.
Your Lordship, oblige, Your Lordship.
You have made your submission.
Yes, I'm concluding.
এটা একটু করে নিন একটা অর্ডার দিলেন কি রেসপন্ডেন্ট নাম্বার 3 appear today না রেসপন্ডেন্ট নাম্বার 3 অবকলতম ফাইল অন বিহাফ অফ রেসপন্ডেন্ট নাম্বার 3
Point number 3.
3 we take on record this is the matter of tomorrow করে দিন এই হ্যাঁ হ্যাঁ মসিনে এই electricity matters.
Lordship, items 16, 17, 18, I would like to use my opposition, Lordship, because in item number 16, Lordship, this is the second round of litigation. But it has not been disclosed before this court. So I will file all the document by way of affidavit.
Can it go to Lok Adalat?
16.
Can it be taken up by Lok Adalat?
Lordship,
Can it be taken up by Lok Adalat?
it can't be.
Item number 16, but
Because meritorious case, I have to argue. Let me use my opposition, Lordship. I have received the copy.
Exception to the report be filed with.
Exception to the report, I have received it.
I find objection to the report.
Objection.
Time was given, yes. Yes.
That is.
Time was given to them to file that reply.
I will use my opposition, Lordship, incorporating all these documents because reply will not serve. I have to incorporate all these
That's
documents.
what time was given.
It is for the petitioner to take an exception. And a reply to the exception.
Yes.
Yes. By way of an affidavit, I will file it.
And when have you filed?
I filed long, but.
Not long back, in this week.
First time was there, within time I filed, within time.
You want to take an exception to such a report?
First August I filed, first August.
You filed an exception to the report
Yes,
filed by him.
Yes.
I filed. He
And
filed a report, I filed exception to the report. On first August, he copied. to the-
I have copy where I can show that what was the condition of the house on 26th March 2025 and thereafter, because I have to enclose all the documents. Lordship.
I declare that on behalf of the advocate for the respondent. Time to file, commonly time to file. A reply to the exception. By
2 weeks.
2 weeks. Place the matter before the next available Saturday. 16, 17 and 18 all.
My lord,
All, Lordship. I will use my opposition because I have find many increment documents, Lordship. So I have to file my opposition.
Last chance, without recording your taking it. Because the community.
He is not fulfilling all the
That is
required.
different,
Let it-
that is different. Fulfilling or not different.
Peremptorily put it up, peremptorily. Next circuit, 16, 17, 18 all. अरे डाक्टर आप कॉल करते हो टाइम नहीं
Item of 17.
I will use my opposition, Lordship.
My lord, there was a confusion what happened yesterday, my lord. I want to brief some facts, my lord. I need to submit something so as to.
Let me file my
If the
opposition.
affidavit was filed,
My lord, that's a bit dicey matter, so I need to explain the matter. Maybe I will.
what will I do after getting explained? After getting explained, what will do I?
Try to explain my side.
Man, for your satisfaction.
If me, the time is allowed.
Exactly. Next circuit. Next circuit.
Obliged, Lord.
Huh? 16, 17, 18, 20, next circuit. And
Obliged.
I'm not calling the hearing matters. Huh? No. I'll not be able to deliver judgment.
Item number 2021, the second appeal and counter appeal.
It is, will it be possible?
Your lordship, item number 23, 34, not today, your lordship. Your lordship, item number 13, please to the next one.